All right, Wednesday, April 15th, federal court, unsealed documents. Melania Trump, Jeffrey Epstein, 23 emails. According to court filings, communication spanning 3 years. I pulled the records, 89 pages, read through them twice. Here's what's actually in there. Not headlines, not speculation, what the official documents show. Judge's statement dropped yesterday. The arrest question, more complicated than Twitter thinks. I've been tracking this case for weeks. Wednesday's unsealing changes the picture. The filings are public record. I'll show you the specific pages, quote the actual language, real breakdown, no hype. Let's get into it. Quick context, Melania Trump, former First Lady, rarely involved in public legal matters. The issue, newly unsealed civil court documents reveal previously unknown communication with Jeffrey Epstein's network between 2003 and 2006. Timeline, fast version. Years back, civil case filed by Epstein victims. Thousands of pages sealed, ongoing legal battles over disclosure, privacy versus public interest. This week, federal judge ruled portions must be unsealed. Wednesday's release included communications involving multiple high-profile individuals. That's the setup. Now the documents. What makes this different from previous Epstein document dumps? These weren't in the main case file. They surfaced from a separate civil discovery process that's been grinding through courts for years. The emails themselves, according to the filing, were retrieved from servers belonging to entities connected to Epstein's business operations, not personal accounts, corporate infrastructure, which matters for context. The court didn't unseal everything, redacted portions throughout. Judge balanced disclosure against privacy claims. What we got? Partial picture, but significant. Now the specifics. Okay, the evidence. First document, filed Wednesday. I pulled page 34. It says, quoting here, email correspondence between MT and JE entity representatives regarding property consultation services, March 2004. That's not my take. That's the filing. What it means? Communication documented through business channels about real estate matters. But here's what got me. Page 47, different section, lists 23 separate email threads, dates ranging 2003 to early 2006. 7 involved direct exchanges, 16 copied on correspondence with Epstein-linked consultants. Put those together? Yeah, pattern of professional contact. I went through this 3 times. Documentation's clear on timing. First contact, April 2003. Introduction through mutual business associate. Peak period, 2004. 11 emails that year. Final exchange, February 2006. Months before federal investigation became public. All documented in Exhibit C. Now, what nobody's covering. Page 61 contains a specific detail. One email from August 2004 discusses interior design consultation for Mar-a-Lago property. The consultant worked for a Epstein-affiliated design firm based in Manhattan. Read that again. Business transaction through entity he controlled. Doesn't prove wrongdoing, proves connection that wasn't previously public. Another thing, the filing shows 4 emails from late 2005 marked calendar coordination and subject lines. Court documents indicate these involved scheduling for design reviews. 3-week period, November into December. Timing matters. Federal investigation of Epstein started 2005. Not clear if these emails occurred before or after that investigation began. Document doesn't specify. What it does specify, communication existed. Volume wasn't massive, but consistent over 3 years. Page 73, financial records reference. One transaction listed $47,000 payment to the design firm for consultation services, January 2005. Payment came from Trump Organization entity. Standard business expense invoice attached as exhibit. Services rendered, interior design consultation, fabric selection, furniture placement recommendations. Nothing illegal there, nothing unusual about hiring consultants. What's unusual, the firm's connection to Epstein wasn't widely known at the time, maybe not known at all to clients. Here's where it gets complicated. The filing includes testimony from the design firm's former office manager, deposed in 2019. She stated, page 81, I handled scheduling for client meetings. I don't recall MT ever visiting our office or meeting with JE directly. That's under oath. But the emails exist, so communication happened. Question is, what kind? The document shows business correspondence through intermediaries, payment for legitimate services, no evidence of social relationship, no indication of knowledge about Epstein's criminal activity. That last part's important. Timeline matters. Most of these emails are 2003 to 2005. Epstein's arrest was 2006, conviction 2008. The scope of his crimes wasn't public knowledge during most of this period. Fallout from Wednesday's release, social media exploded immediately. Privacy advocates claimed overreach. Victims' attorneys called it necessary transparency. Within 48 hours, 3 major news investigations launched. Congressional members demanding full documents. Trump family attorneys filing objections to further disclosure. Court stays silent on next steps. That's just the first batch of documents. Subscribe. More coming on this as additional pages get unsealed. I break down what headlines skip, primary sources, not hot takes. Okay, but look, got to be fair here. The other side has a point. Few points, actually. Privacy advocates and Trump family legal team say this is selective disclosure designed to create false implications. And honestly, some of it holds up. Their argument, first, business communication doesn't equal personal relationship. People hire consultants all the time without knowing who owns the firm. Second, timeline shows contact ended before Epstein's crimes became public, suggesting victims' attorneys are conflating unrelated business dealings with criminal activity. Constitutional attorney Harmeet Dillon put it this way: unsealing private business records without evidence of wrongdoing sets dangerous precedent for everyone's privacy. Don't agree with all of it, but that's not nothing. What they've got? No evidence in documents of personal meetings between Melania and Epstein. All communication appears transactional and business-related. Payments match standard rates for design consultation services. Even legal analysts not aligned with Trump family admit the emails themselves are, quote, unremarkable from a legal standpoint. That's from former federal prosecutor Jennifer Rogers. She's no Trump defender. Look, I'm not here to tell you who's right. Victims' attorneys' interpretation? These emails show Epstein embedded himself in elite social networks through business fronts. Evidence supports that. Privacy advocates' interpretation? Innocent business dealings are being weaponized for political purposes. Evidence there, too. Both can be true. That's what makes this complicated. The legal team's also pointing out inconsistency. Why unseal Melania's business emails but keep sealed other correspondence involving people actually accused of wrongdoing? Fair question. Their filing from Thursday argues the judge applied different standards to different people. Political figure gets exposed, others protected. They cite specific examples. Pages kept sealed involving a Wall Street executive, a foreign diplomat, 2 entertainment industry figures, all had more extensive contact with Epstein, all still redacted. Why the different treatment? Judge's explanation from the Wednesday ruling. Public figure status and previous public denials of any Epstein connection justify disclosure in this instance. So basically, you're famous, you said you didn't know him, now we're checking. Privacy advocates say that's not how law should work. And look, there's another angle. The timing. Why now? These documents have been in court files for years. Judge could have unsealed them any time. April 2026, year before major political cycle, potentially involving Trump family members. Conspiracy? Maybe not, but optics are bad. What I can tell you, what the documents show, and they show business-level communication between 2003 to 2006. Nothing illegal in the emails themselves, but a previously undisclosed connection to Epstein's network. How you interpret that depends on what you think these document releases are really about. This didn't come out of nowhere. Backstory, quick. Years ago, Epstein case exploded. Victims filed civil suits, demanded full disclosure of his network. Courts faced dilemma, transparency for victims versus privacy for people who may have had innocent contact. Result, years of litigation over every document. Ongoing, each release gets fought. Motions, counter motions, appeals. This particular batch was part of a subset of documents from business entities, not personal correspondence, corporate email servers. Someone even said, on record, back when this process started, we'll be fighting over these documents for a decade. That was 2019. They were right. What happened with previous releases? Pattern. Documents unsealed, media frenzy, most communication turns out mundane, few revelations actually newsworthy. Every time, public assumes worst, reality usually more boring, until sometimes it's not. That's what keeps attention on each release. The Melania emails, in context of other unsealed documents, are actually less extensive than many. Some individuals had hundreds of emails. In-person meetings, flight logs. Her case, 23 emails, all business correspondence, no flight logs, no party invitations, no social events documented. But she's also never been named in previous releases. First appearance, that's why it's news. Until Wednesday, Trump family line was no connection to Epstein beyond Donald knowing him socially years ago. Now there's documented business connection through Melania. Changes the narrative. See where this is going? Hit like if this breakdown helps. Sorting fact from narrative takes time. That like actually helps more people find this. Wednesday, 2:17 p.m. Eastern. Here's what happened. Court clerk uploaded the unsealed documents to the public docket. Within minutes, journalists downloading the files. 89 pages. Search functions activated immediately for Trump. Page 34, there it was. Newsroom reactions, immediate scramble. What followed? First headlines within 30 minutes. Trump family attorneys issuing statement within 90 minutes. Social media explosion by 4 p.m. 4 hours. That fast. Now, what everyone missed. While people focused on Melania's name appearing, something else happened. The judge's accompanying statement included a footnote. Page 2 of the order, it referenced additional materials under continued seal pending resolution of emergency motion filed April 14. Emergency motion filed the day before release. Then the arrest question. Thursday morning, headline from Courthouse Reporter. Does judge's order contain arrest directive? Answer, no. But there's complexity. Page 7 of Wednesday's order includes this language. Any individual who fails to comply with court-ordered testimony pursuant to ongoing depositions may face contempt proceedings. Not Melania specific, general statement about the broader case. But one attorney in this case, representing a different witness, has been dodging deposition for 6 months. Judge's patience ran out. That language is a warning. Media coverage conflated two separate things, made it sound like arrest order for Melania. Wasn't. Different witness, different issue. But algorithms don't care about nuance. Judge plus arrest plus Melania plus Epstein equals viral. The actual legal threat in this case, civil contempt for non-cooperation, not criminal charges, not arrest warrants for anyone in the documents. Standard court enforcement procedure. Judge Loretta Preska, she's handled this case for years, known for strict procedural compliance. She issues contempt warnings regularly. This one just happened same week as Melania document release. Timing created confusion. You could see it in the docket sequence. Two separate orders, same day, media merged them. This is where careful reading matters. Don't go anywhere. What I show next explains why this story's bigger than one person's emails. Drop your prediction below about what happens next, then keep watching. What are experts saying? Former Assistant U.S. Attorney for Southern District of New York, 14 years prosecuting financial crimes. Document releases like this rarely produce smoking guns. They provide puzzle pieces. Plain English, individual emails look boring. Pattern over time might not be. Another one, criminal defense attorney specializing in high-profile cases. The question isn't whether communication was illegal, it's whether it contradicts previous sworn statements. Key there, if anyone testified under oath about not knowing Epstein's businesses, these documents matter. Here's what's interesting. Even legal analyst Glenn Kirshner, frequent Trump critic, admits nothing in these specific emails suggests criminal knowledge or activity. When both sides agree on the basic facts, pay attention. The disagreement isn't about what the emails say, it's about what unsealing them accomplishes. One camp, transparency for victims outweighs privacy concerns. Other camp, phishing expedition designed to embarrass people through guilt by association. Legal scholars landing somewhere in middle, Professor Stephen Gillers, NYU Law School expert on legal ethics, courts must balance victim rights with protecting individuals who had innocent contact. It's case-by-case analysis. Translation, no easy answer. Judges making judgment calls. Consensus among legal experts I've reviewed, documents show business relationship existed, no evidence of criminal wrongdoing in emails themselves. Timing of contact before public knowledge of crimes is significant. Contradicts no connection narrative. Doesn't prove knowledge of illegal activity. That's where professionals land. The contempt question, separate issue, legal analysts say is standard procedure. Judge enforcing cooperation. Former federal magistrate judge, contempt threats are tools for compliance, used frequently, usually work without actual arrest. So the arrest angle, overblown, but not entirely baseless, just misapplied. Useful breakdown? Hit like. Separating legal process from headlines takes time. Your engagement tells me this format works. Like for more of these. Why should you care? Real talk, how this affects actual people. This sets a precedent about privacy in the digital age. Next time you send business emails, those could theoretically surface in litigation years later. Different context, different interpretation. Quick example. You hire a contractor for home renovation. Turns out, years later, that contractor was involved in fraud, completely unrelated to your project. Your emails discussing bathroom tile could get subpoenaed, made public. People online assuming you were part of the fraud. Not dramatic. That's how civil discovery works now in high-profile cases. Right now, approximately 170 individuals named in various Epstein-related sealed documents still fighting disclosure. Some definitely guilty of wrongdoing. Others probably had innocent contact. Courts deciding case by case who gets privacy. Next round of unsealing expected within 60 days. If you vote or follow politics, this matters for 2027-2028 cycle. Trump family members potentially running for various offices. These documents become opposition research. Not saying emails show wrongdoing, saying they're now ammunition. Voters deserve full picture, also deserve context. You'll see these emails in campaign ads, probably without the nuance, without timeline, without business correspondence through intermediary explanation. Just Melania Trump plus Jeffrey Epstein plus 23 emails. How you evaluate candidates, your call, but know what you're actually looking at. Wednesday's release is a case study in how stories develop. 2:17 p.m., documents posted. 2:45 p.m., first headlines. Melania Trump named in Epstein documents. 3:30 p.m., secondary headlines, secret emails revealed. Thursday a.m., judge orders arrest, trending on social media. By Thursday afternoon, clarifications that arrest order unrelated. But first narrative stuck. That's what people remember. If you consume news, any news, watching how this story evolved shows why checking primary sources matters. I read the actual filing. Most coverage didn't quote it directly. That gap between document and headline is where misunderstanding lives. Uncomfortable part. Lots of wealthy, powerful people did business with Epstein, used his connections, hired his associates. Most probably didn't know about his crimes. Some definitely did. Documents can't always tell you who knew what. If you're in business, networking, any professional field, you've probably crossed paths with someone later exposed as corrupt. Not your fault, but association exists in records somewhere. That's reality of living in connected world. Not trying to scare you, just pointing out degrees of separation are smaller than we think. What informed people doing? Reading actual court documents before forming opinions. Distinguishing between connection and wrongdoing. Asking lawyers about context before sharing inflammatory claims. Knowledge helps. Nuance matters. How'd the Trump family respond? Made it worse, honestly. Well, more complicated. First statement came fast, 90 minutes after documents posted, from Melania Trump's attorney. Mrs. Trump had no knowledge of Mr. Epstein's crimes and used standard business services in connection with property consulting. Fine, reasonable. Then, the follow-up. Thursday afternoon statement added, this politically motivated disclosure ignores that dozens of more relevant documents remain sealed. That language, politically motivated? Reaction from legal community? Judge Preska, who ordered unsealing, is Republican appointee. Case predates current political cycle by years. Victims' attorneys, not political operatives, pushed for release. Calling it political motivated opened different line of attack. Now coverage isn't just about the emails, it's about the response's accuracy. Victims' attorneys came back hard. Sigrid McCauley, representing multiple Epstein victims, survivors seeking truth about who enabled their abuser is not politics, it's justice. Then Melania's legal team filed motion Thursday evening requesting resealing of documents, emergency request. Argument, release violated privacy rights, serves no legitimate purpose, causes irreparable harm. Judge hasn't ruled on that yet. Legal experts I checked with, motion unlikely to succeed, documents already public, can't put toothpaste back in tube. But filing it keeps story alive. More headlines, more coverage. If goal was making this go away, didn't work. Not cooling down, heating up. Media cycle normally moves on fast. This one's got legs, multiple angles, legal fights continuing. What's still unclear? One, the additional materials under continued seal the judge mentioned. What's in those? Who's in those? Two, why these specific emails got unsealed but others didn't. Decision criteria not fully explained in ruling. Three, whether anyone in these documents contradicted previous testimony. That's when this gets legally serious. Coming events. Judge Preska has status conference scheduled Monday, April 20. All parties required to attend. She'll likely address the resealing motion then. Victims' attorneys reportedly preparing motion for additional disclosure. Sources say it targets financial records, could file early next week. Trump family legal team preparing counter motion. No specifics public yet. Date to watch, April 24. That's deadline judge set for resolution of the emergency motion referenced in her Wednesday order. Still don't know what that motion involves, who filed it, what they're trying to stop. Court watchers expect more documents could drop that day, depending on ruling. Also watching congressional response. 3 senators requested full case file briefing. DOJ hasn't responded yet. Should know more by end of next week. Subscribe. When that April 24 deadline hits, I'll break down what drops. Stories moving fast, notifications on so you catch the update. Where we are right now, 89 pages unsealed Wednesday, more remain sealed. Melania's legal team fighting resealing, motion pending. Victims' attorneys pushing for additional disclosure. No evidence of criminal wrongdoing in released emails. Pattern of business contact between 2003-2006 documented. Arrest order narrative was misapplication of contempt warning for different witness. Scheduled April 20, Monday, status conference, Judge Preska presiding. April 24, Friday, deadline for emergency motion resolution. Late April, early May, expected next batch of unsealing decisions. Not public yet, contents of still sealed portions, dozens of other individuals' documents under review, outcome of resealing request, legal process ongoing. This case has been in court since 2015, likely continues for months or years more. Victims' attorneys have stated they'll pursue disclosure of every relevant document. Hundreds of pages still under seal. Each release gets fought. Each ruling gets appealed. Clock's running on multiple motions right now. Trump family deciding whether to appeal this unsealing. That could delay further releases, but also extend the news cycle. That's where we are. Melania Trump, documented business contact with Epstein network, 2003-2006, now public record. Surface read, guilty by association, scandal, cover-up. But the emails themselves show routine business correspondence, payment for legitimate services, communication through intermediaries. Timeline matters. Contact ended before crimes became public. Absence of evidence isn't evidence of absence, but it's not evidence of guilt either. I'll be watching Monday's status conference, what the judge says about resealing motion, whether more materials get released April 24. Also watching how this plays in political sphere versus legal sphere. Different standards, different stakes. Story's not over, still developing. For victims, every document release is a step toward understanding who enabled Epstein. That matters. For people named in documents, some innocent, some not. Court trying to figure out which is which. For all of us, case study in how partial information creates narratives, how headlines diverge from source documents, how timing shapes interpretation. Subscribe for the full picture, not just headlines. When documents drop, I'll break them down, page by page when needed. Court records are public. We can read them, should read them. Talk soon.